Good evening. Good evening, everybody. For those of you who don't know me, my name is Jim Anaya, and I'm the Dean of the Law School. Welcome to this year's Coen Lecture. The namesake of this lecture series is John R. Coen, who was a distinguished member of the Colorado Bar. After his passing, his widow, Adrienne Coen, established in 1955 this lectureship in his memory. The purpose is to bring a prominent and distinguished lawyer, jurist, or scholar to deliver an annual lecture to the Colorado law community on a subject of public interest and benefit to the legal profession. We're pleased to welcome, as the 61st Coen Lecture, Gregory B. Craig. Mr. Craig is a highly distinguished lawyer whose career has included government service, the practice of law, teaching, and a variety of public interest activities. Currently, he is of counsel at the Washington, D.C. office of Skadden, Arps, Slate, Meagher, and Flom, where he chairs the firm's Global Policy and Litigation Strategy Group. Details about Mr. Craig's illustrious career are in your program, but allow me to highlight a few things. He served as White House counsel under President Barack Obama from 2008 to 2010, was the lead attorney in the team of lawyers that represented President Clinton in the Senate impeachment trial in early 1999. He served as the director of the policy planning staff for Secretary of State Madeleine Albright, and was a senior advisor to Senator Edward Kennedy on national security affairs and foreign policy issues. In addition to his public service, Mr. Craig has many years' experience as a trial lawyer. Just a few of his clients in many high-profile cases are Russian Nobel Prize laureate Alexander Solzhenitsyn, Secretary General of the United Nations Kofi Annan, Juan Miguel Gonzalez, the father of Elian Gonzalez, and John Hinckley, the individual who attempted to assassinate President Ronald Reagan. True to being a first-rate trial lawyer, Gregory Craig is also a great performer. And I'm not just talking about his time as a member of the Harvard Crocodillos a cappella group. He impersonated President George Bush in the mock debate to prepare John Kerry for his bid for the presidency. And then he portrayed John McCain in the process of preparing Barack Obama for his presidential debates against John McCain. And I bet you that he rivals Dana Carvey in that impersonation of President Bush. With his vast experience that includes engaging with many of the noteworthy political figures and events that mark recent history, Mr. Craig is well suited to comment on the current conditions of our country as they relate to the rule of law. He joins us this evening to speak about a question about the State of the Union. Is the rule of law strong? Please join me in welcoming Greg Craig.
I should call it quits right now because there's no way I'm going to live up to that. In the interest of some disclosure, not full disclosure, I should tell you that I've known Jim Anaya for over 35 years and knew him back in the day when I was working for Senator Kennedy and he was making peace in Nicaragua. And we traveled through the war. He was skinnier then and so was I. And we were both vigorous, but he was very brave and courageous because he stuck with it over a long period of time and made a real difference. And the last time actually I saw Jim in Washington, D.C. was when he argued a case in front of the Supreme Court. He did very, very well, I thought, by my standards, but he came in second. So I must say that the University of Colorado Law School is very lucky to have Jim Anaya, both an activist, an appellate lawyer, and an academic, and a really good guy to be your dean. And Jim, it's good to see you again. And I thank you for the invitation to deliver the 61st annual John R. Coen Lecture here in Boulder. And I must say, I did look at the list of the people who had given this lecture before in the past, and I think you've got some problems with your vetting that you end up with me. But I do think that maybe talking a little bit about vetting at this point before I get to the rule of law may be appropriate, because it's an issue in these past few days. And we've been reading about how vetting has been working or not working in the White House. And we've seen in some painful detail the price you pay when the basic principles and the purposes of vetting are ignored for some reason. Now, I feel as though I can speak with some authority because I've had those painful moments. And when I was a lawyer in the White House, I was in charge of vetting with our team, many presidential appointees, including a Supreme Court justice and various other candidates for the courts, for cabinet, sub-cabinet appointments, for ambassadorial appointments, as well as for senior staff in the White House. And if you'll just give me a moment to pat ourselves on the back, I take some pride in not only our record up through 2010, but in the record of the Obama administration, all 8 years, of a record of avoiding embarrassment and scandal and conflict of interest. And I think we were largely successful in our effort to identify problems and then to make the tough decisions. To have a good vetting process, it does require a basic understanding of the hazards of conflicts of interest and why conflicts of interest are bad and to be avoided. It requires an understanding that a conflict of interest can compromise the most distinguished public servant and undermine the wisest public policy. And it requires making an effort to spot and to avoid those conflicts of interest and to prevent even the appearance of a conflict. And in my experience, it's not easy, particularly from those people in the private sector, largely who come into government from careers of great success at the pyramid of a corporation or a financial institution. And suddenly, they're not happy about the detailed investigation that they have to go through, the questionnaires that they have to fill out, and the time that this all takes. But I think we did it well, and I think that the White House under President Obama was one of the best in modern American history when it comes to conflicts of interest. A swamp, it was not. There's one other comment I would like to make, because there's been some discussion about whether vetting should include the right to due process for the subject of the vetting. No one who is truly familiar with the vetting process, whether you're a Republican or a Democrat or something on either side or in between, nobody would say that a effective and successful vetting process, a perfect vetting process, does not have perfection in due process. To be sure, decision makers that I was working with and associated with tried to be fair to everybody that was going through the process, but there was never any sense that due process was a requirement for vetting to be successful or in making vetting decisions. Sometimes, unfortunately, decisions were made on imperfect information, but they had to be made anyway. And we made a point of telling our job seekers that they would always have a chance to tell their side of the story, but they could not rely upon a litigation if they disagreed with our judgment. A litigation to protect them from the decision that we might make that there was a problem in their background. Now, this is a very long way of saying thank you for letting me survive the vetting process. I'm very honored to be here, and I'd like to talk a little bit about the state of the union as I see it in 2018 when it comes to the rule of law. Now, the idea of this topic, which Jim had invited me to come and talk to you all about, the idea came to me when I was not watching President Trump's most recent State of the Union address. And I don't want that remark to be taken as a gratuitous criticism of President Trump. I've been put off by States of the Union address for many, many years now, and I think any candidate running for president in 2020 would be well advised to include in his platform the promise that at least for a couple of years he will not come and address the Congress and give a State of the Union address. Why is that? Because I think sadly it has become an exercise in political posturing and pandering on all sides and demeaning to everyone, and it doesn't really enhance the institutions that are engaged. This is not, by the way, a new thought. This is something that has been discussed over some period of time. And it may be true that the pollsters can measure this and conclude that actually one of the reasons public servants are held in such low regard today is because every time they participate in the State of the Union speech, their approval rating is not enhanced. I would say there was one exception when Congressman Kennedy gave a response that I thought was very effective, and I would say that was an exception to the general rule that those who participate in the State of the Union festivities generally suffer in their public approval rating. Now, I believe that the rule of law in the United States in 2018 is suffering from neglect and disrespect, and it is in disrepair. It has in recent years been systematically degraded, not just by this president, but by many active American leaders who are on the scene today in and out of government. It has had an impact because from all sides, I think the public's faith in our most fundamental institutions has been seriously diminished after 20 years of gridlock and grandstanding, to the extent that it feeds wild conspiracies and theories of what causes things to happen these days that are unrelated to the reality. It fosters many different politically driven views of reality, and it invites foreign interference. So I think the result is that many younger Americans today ask themselves when they look at the scene whether good governance can ever occur again, whether peaceful change will ever be possible again. Now, speaking as someone who grew up in the 60s, I recognize that there's nothing really new about Americans having serious questions about the integrity and the viability of government institutions. This was, as many of you know, a topic of great debate in the 60s, and it was certainly most intense among members of the under 30 generation, which included me. We may have caused, as we've had these discussions, a right-wing backlash that was fed and fostered by Richard Nixon and Spiro Agnew and may still be with us today. But not surprisingly, my generation's love-hate relationship with government institutions in large part arose out of our experience in the civil rights movement as well as the anti-war movement. Back then, we had political parties governed by bosses who operated in the back room with very little public accountability or reference to public morality. We witnessed the assassination of some of our most admired leaders and bravest heroes. We faced a military-industrial complex that, with endless resources and no visible constraints, could bend institutions of government to its will in support of bloody wars in distant lands. And we faced a Congress that we thought was corrupted by special interests, was controlled by regional interests, and was governed by ancient and outmoded rules such as the filibuster and the seniority system. Nonetheless, we struggled through all that, and the country changed in ways we never could have predicted. And for a while, it was possible to be pretty optimistic about our future and, in fact, the state of the rule of law. But recent developments and some very specific events, I think, threaten to replicate and reproduce that perfect storm of wind, thunder, and lightning that disrupted our democracy back in the 60s and which I think may lead to another cycle of cynicism. Let me just list a few events that I think have relevance to the state of the rule of law today, but may be gathered under the heading of, quote, rigging the system against the people. Point one, by vitiating campaign finance laws and limitations and concluding that American corporations have First Amendment rights and political rights the same as American citizens, the Supreme Court has empowered wealthy individuals and corporations to exercise their wealth and stack the deck and predetermine, it seems, the outcome of many of our nation's political processes. Point two, by undertaking a decades-long, relentless nationwide effort consciously and systematically to prevent certain categories of citizens from voting, entrenched political interests have, in many states and municipalities, tried and sometimes succeeded in preventing voters from voting, reducing turnout, and sabotaging free, full, and fair elections. Point three, by drawing district lines to maximize the impact of certain blocks of voters and to minimize the impact of others, both parties over the past decades have created a national system of gerrymandered jurisdictions which, apparently in violation of the one man, one vote principle, empower electoral minorities to dominate electoral majorities and also strengthen the extremes in both parties, weaken the center, polarizing the electorate, and making compromise politically difficult, if not impossible, not just in Washington, but in state capitals all over the country. Point four, by ignoring the Senate's constitutional role and duty to advise and consent on presidential nominations to the Supreme Court, the majority leader in the Senate single-handedly deprived President Obama and millions of American voters who voted on 2 occasions to elect him president of his constitutional power as president to fill a vacancy on the Supreme Court. It was, in my mind, a great affront to the Constitution, almost as if the nomination had never been made. Now, the president nominated a man who was respected by all, but that nominee was not given either a hearing or a vote in the Senate. Had he done so, he would have been confirmed very quickly had he been given that chance. Let me just give you a comparison about time consumed in confirming justices of the Supreme Court. When President Obama nominated Sonia Sotomayor, it was June 1st, 2009. She's a more controversial nominee than Merrick Garland was. She was confirmed just 2 months later on August 6, 2009. It's likely that Merrick Garland, nominated on March 16th, 2016, would certainly have been nominated long before the election took place 8 months later in November. And finally, in November 16, for the second time, this is in the category of the rigged system, as seen by many. In November 2016, for the second time in the most recent 5 presidential elections, a person became president of the United States, having lost the popular vote by a margin of many millions of votes, but being elected nonetheless as a result of having marginally more votes than his opponent in 3 other closely contested states. Now, some of these problems are structural problems that can't be changed just by a good voter turnout in 2018. And these developments that look so much like efforts to rig the system may explain why many Americans have lost confidence in our institutions of government, in the rule of law, and no longer trust the character or the integrity of our political leaders. But I'd like to talk just a little bit about where the concept of the rule of law comes from. I think it's much more than just obedience to the law or compliance with the law or clarity in the law or efficiency or even application of the law or fair enforcement. These concepts and principles are, of course, at the center of the understanding of what the rule of law is, necessary and important to what we think of as the rule of law. But in my mind, measuring our fidelity to the rule of law as a society and as a country by examining only these particulars falls short of a full appreciation of what a society with strong, consistent, and robust respect for the rule of law is all about. It was tempting for me to go through various Supreme Court justices, all of whom you have heard, or legal philosophers, and get great quotes about what the meaning of the rule of law all is. And we are all proud to say that the rule of law means a nation of laws, not a nation of men, that laws govern a nation, not the whims of individuals. And I can tell you a story about carrying Edward Bennett Williams's bag when he argued in front of the Supreme Court, having to do with the issue of whether wiretapping without a search warrant, that just tells you how old I am. Wiretapping without a search warrant was wrong, even if the person whose phone was being tapped was in the mob and guilty of sin. That was, he had to concede that at the beginning and saying still it was necessary to have a warrant. He pointed out that the difference between Soviet Russia and the United States is to be found in the fact that in Russia they put Lenin and Stalin under glass. In the United States, it's the Constitution and the Bill of Rights that is under glass. This is what we revere and respect. It is these documents that we protect and honor, which I think is a fitting representation of what the differences are between a nation that is ruled by a constitution and the laws rather than a nation that is ruled by an individual. Let me just say, as a practitioner, I love rules. I really need rules. And there was a period of my time, of my experience, when I suddenly found myself facing a trial in a court without rules, without standards. There are, in most federal courts, all federal courts, the rules, federal rules of civil procedure that tell you how to conduct a civil trial. There are also the federal rules of criminal procedure that tell you how a criminal trial, the discovery, the motion practice should be run. When you are in the Senate conducting a trial of an impeachment, there are no federal rules of impeachment procedure. And we arrived the day the trial began without understanding what was going to happen at this trial. Would there be discovery? Would there be pretrial motions? Would there be briefs? Would there be opening statements? Would there be closing statements? Would witnesses come in and testify? We had no idea, and nobody in the Senate did as well. It took the senators with the Republicans gathered around Trent Lott on one side in a huddle, and the Democrats gathered around Tom Daschle on the other side in a huddle to agree that the first thing they should do is go meet secretly somewhere where nobody could watch their confusion and come up with at least a beginning for the trial. And that's what they did. But it was as a lawyer who feels comfortable when he knows what the rules are, that was a maximum discomfort. So please understand that I do appreciate the rule of law as it applies in my life. There was another moment when it was clear that there were no standards governing the impeachment, and that was near the end. We realized that if we kept all the Democrats together, we would be able to prevail in the trial because it requires a 2/3 vote to remove President Clinton from office. And we thought we had at least all the Democrats and really a good bunch of Republicans who were also going to support us in the idea that the president should not be removed. He was not guilty. He was not removed. He should not be removed from the presidency. 2 days before the vote on whether or not he should be found guilty and removed or acquitted, the dean of the Democratic caucus, Robert Byrd, went on national television, interviewed by Cokie Roberts, and Cokie asked Senator Byrd, well, do you think President Clinton is guilty of lying in the grand jury? Oh, yes, he did that. Do you think he's guilty of obstructing justice in securing a perjurious affidavit from Ms. Lewinsky, or giving her job opportunities, or giving her presence? Oh, he did that for sure. So there is sort of the leading senior Democrat, 2 days before the vote, telling the world that he thought President Clinton had committed all the acts that were the subject matter of the articles of impeachment. And you know how he voted. He voted not guilty. And the reason he voted not guilty was because he thought it would be bad for the country, which is a perfectly good reason to vote not guilty. It would have been bad for the country. But that tells you a little bit about what the standard is or isn't that applies in an impeachment proceeding. There's no instruction from the judge that's going to say, you have to evaluate the evidence, and if you believe beyond a reasonable doubt that the defendant committed acts alleged, then you have to find him guilty. The impeachment process is not an adjudication, really, of guilt or innocence. It's a political process to determine what is best for the nation. Has the president threatened the nation, abused his power? Is it important to remove him from office to protect the country? And just on this point, maybe it's because I still like to live in the past a little bit. The closing argument that Chuck Ruff gave, and Chuck Ruff was really our leader in this impeachment defense. He was the White House counsel. He put it in a very important and accurate way. He said, there's only one question before you, one that is a question of fact and law and constitutional theory. He's talking to the Senate. Would it put at risk the liberties of the people to retain the president in office? Putting your partisan animus aside, if you can honestly say it would not put the people's liberties at risk, and that those liberties are safe in his hands, then you must vote to acquit. Now, I thought that was a very powerful instruction. You know, Chief Justice Rehnquist, who is presiding over the trial, never gave instructions to the senators about why they should vote or how they should vote or what they should consider or what the standard of proof should be. It was up to each and every senator. It was fundamentally a political exercise. But I do believe that the rule of law and respect for the rule of law was very important there. Let me just identify two or three other, just to make the case that the rule of law is more than just rules in courts and the way judges act and the way lawyers argue, that it has to do with society's attitudes as well as a culture, as well as conduct, general conduct. One of the worst moments in my lifetime for the rule of law was when our society was driven by distrust and fear and the dread of communists in our midst, and this was during the 50s, when it was thought that they must be rooted out before they corrupted and perverted the country. Now, most of you, some of you probably remember those days, but most of you don't because you weren't around, but it was one of my earliest memories, and I actually heard it happen as it was unrolling on radio. That's where I first heard the word memorandum. I was about 5 or 6 years old, and I remember hearing on the radio the word memorandum and asking my parents what that meant. But this was a terrible time for the rule of law. You know, the careers and lives and reputations of many American citizens, of artists, of actors, of filmmakers, not just government servants, but also academics and intellectuals were destroyed, damaged. And it was a period in our history when the rule of law was at its weakest. I think another example of this type of societal failure to respect the rule of law was when there was massive opposition to the Supreme Court's opinion in Brown versus Board of Education, not just in the South, where it was well organized and visible, but also in the North. And I think this too represented a low point in the history of the rule of law, which brings me to today. And I'm going to be somewhat specific today and move away from examples from the history book. Can the rule of law be strong in a society where leaders do not comport with the basic norms that govern private or public conduct? It's a good question. Can there be a strong rule of law society, one that is truly dedicated to the phrase that's carved on the facade of the Supreme Court, equal justice under the law, when the leaders of that society use racist rhetoric and in their daily lives do not respect or treat all citizens equally? Is the rule of law strong in a society where truth-telling is the exception, not the rule, where rules governing public conduct are ignored and dismissed, where leaders actually attack the very existence of rules and the act of rulemaking, even when they are intended to protect the public, the purity of our air and our water, and are accused of being antithetical to public well-being and damaging to the public welfare? It's my judgment that all of this has an impact on the rule of law. But we are not, if you look back at these moments when the rule of law was weak, the decision to authorize the use of enhanced interrogation techniques or torture, the decision by the House of Representatives to impeach President Clinton. I think the Supreme Court's decision, Bush versus Gore, is another moment. The Nixon administration's use of its administrative and executive powers to attack and destroy political opponents by corrupting the IRS and the CIA and the FBI. The decision to go to war in Vietnam and the effort to win that war by manipulating and manufacturing evidence. And we now have this wonderful movie that talks about the Pentagon Papers, which tells us that part of the problem back then was concealing the truth from the American people. And so concealing the truth, I think, has effects on the rule of law. But looking at these incidents in the recent past, it seems to me that we are not yet today dealing with anything comparable to those examples. And the second thing we can say is that in light of how severe those incidents were, we should take some comfort in the fact that the American people soldiered through and struggled through and met and overcame what were, in fact, I think, truly serious challenges to the rule of law. But I think there is a likelihood that there will be a serious constitutional conflict or confrontation in the near future. And it would be a mistake, I think, to think that the crisis is not yet upon us. I think it's here today. And let me just list a few incidents and events that come to my mind when I think about what has happened over the last 12 months that has weakened the strength of the rule of law in America today and requires some kind of response. The president's unwillingness to take any steps to comply with the constitutional clause having to do with emoluments, a 250-year-old rule that explicitly forbids a president or any federal official from taking benefits in any form from a foreign power. The president's decision not to take any serious steps aimed at reducing or eliminating the possibility of conflict of interest between his duties as president and his interests and his family's interests in the private sector. The president's repeated criticism of his own attorney general for that person's correct decision to recuse himself from the Russia investigation. The president's personal involvement and participation in creating a false narrative for the public as to the real reason for the meeting between his son, his son-in-law, top officials in the campaign, and Russian citizens who promised dirt on Hillary Clinton. The president's decision to pardon his political friend and ally, Sheriff Arpaio, who had been convicted of the crime of the contempt of court, criminal contempt of court, when, after being ordered to discontinue unconstitutional and illegal ethnic profiling, he and his office continued to do so. There is a racist dimension to this official act that was, for me, deeply troubling. I don't think President Trump violated the Constitution by taking advantage of his power to pardon. That clearly he has. But just because you exercise a constitutional power doesn't mean that you're not abusing it. I think his decision to fire James Comey, which he had obviously a right to do, but using Rod Rosenstein's memo as a pretext and falsely claiming that James Comey was being fired because of his mishandling of the Hillary Clinton investigation, I think that's inconsistent with the rule of law. The president's year-long campaign against the intelligence community and the FBI, most recently by attacking the deputy director and claiming that not only the deputy director, but other members of the FBI and the intelligence community are engaged in a conspiracy against the president and his campaign. The president's use of racist rhetoric in describing the events in Charlottesville and discussing immigration policy towards Mexico and in talking about U.S. immigration issues generally. His war on science, as represented by his decision to eliminate members of science advisory boards to relevant government departments that have anything to do with climate change or global warming. His decision to appoint individuals to positions of great power and authority over government agencies, such as the Environmental Protection Agency, the Consumer Protection Finance Board, the Interior Department, the Energy Department, and the Education Department with instructions to dismantle and destroy these agencies' ability to carry out the law and protect the public's health and well-being. His decision to create a national commission on voter fraud, based on his claim that Hillary Clinton's 3 million vote margin was the result of illegal votes cast by unqualified voters. I probably could come up with some more examples where I think the president has not adequately respected the rule of law and has contributed to a culture that ignores and disrespects the rule of law. So to those young lawyers in this room who are asking themselves, so what do we do about all this? I would say to you, it's not enough to think that by removing President Trump from office, either by impeachment or by election, it's going to satisfy the situation. I do think it's more than that. The antidote to this kind of poison is certainly not more of the same. It is neither a Democratic nor a Republican solution. I think it's a national solution. It requires a national consensus to be built around basic and fundamental national values. Yes, it is true, we must go out in greater numbers than ever to support candidates for public office who support the rule of law. And yes, we must go to court whenever necessary and when possible to check excess. But we should understand that there are friends and allies of the rule of law in all parts of the political spectrum and among all political parties. I could name a dozen Republican commentators, a large number of local Republican leaders, as well as in Washington, D.C., who themselves have taken positions in support of the rule of law in this country. And it will take American citizens from both parties to regain control of this experiment in self-government and to reclaim the spirit. But I do not think that the people in this country will, in the end, follow where this president wants to lead them. And I do believe that what is required first and foremost today and tomorrow and for the foreseeable future is for good men and women to stand up and say there is another way. Now, at lunch today, we talked about what are the kinds of possible concrete reforms that could make this all happen. And I have to say, I don't know when, I don't know who, and I don't know exactly how this can be done, but I do believe in my heart that the American people will not allow themselves to be led down a path that actually turns its back on the American dream, that breaks faith with what has made America great in the past and what will make it greater in the future. And that all the forces aligned against the rule of law, anti-immigrantism, gerrymanderism, populism, racism, those forces will ultimately be reduced, if not finally tamed, by the words and actions of Americans who say no. The electorate, I believe, is not always right or wise. I think that's self-evident. But in response to what we are experiencing today, I think the American people will react at the federal as well as the local and municipal levels and reject the example that our president has set. The American people do not embrace racism. They do not want to live in a country that pits rich people against poor people, men against women, straight against gay, rural against urban, white against non-white. And I believe those of us who have spent our lives in love with this country and working in support of the values of this country should never accept the idea that we are a tiny minority sitting on the edges and the fringes of America, that because we believe in treating people with respect and decency, we are elites to be discounted. On the contrary, I think we are the mainstream of this country, because those who inject intolerance into the lives of our communities do so not to lift up the rule of law, but to divide and to conquer. Those who unleash winds of bias and prejudice do so not to help others, but to benefit themselves. And that's not what this country is all about. People who love the rule of law, respect the rule of law, and revere the rule of law represent the majority and the mainstream of this nation. Watching our own children, we have 5. They're millennials. They're between the ages of 22 and 29. And watching them go through the last 12 years has been a great and a reassuring lesson to our family, because in their young lives, they show concern appropriately, and they take action appropriately to protect the environment, to work on presidential campaigns and local political campaigns, to reduce inequality. They believe in working with others in the world, not going it alone. And every day they show themselves, I think, to be dedicated and concerned and generous. I know they are frustrated. I know they are angry. But I know they will not give up or give in, and neither can we. There's just too much at stake. Thank you very much.
Greg has agreed to take some minutes to answer some questions. So.
Yes, sir.
Well, you've had a very interesting career. I must say, as a citizen, I'm puzzled, because I think you wouldn't disagree that in any attempt to define the rule of law, one principle would be telling the truth. And so how, when you're defending President Clinton, and assumedly you didn't disagree with Senator Byrd, how do you defend?
I did disagree with Senator Byrd.
Okay.
Just stop right there. I did not think he had
Well,
committed.
that would be the question. If you thought he would you have backed away from the defense? Not that I would disagree that he should be impeached, but under the theory of the rule of law and respecting telling the truth.
No, there is a time and a place to reconcile the president's conduct with the requirements of the law, and that would be in the criminal justice system. It's very interesting to compare what happened in the House of Representatives on this issue as compared to what happened in the Senate, because we didn't know exactly what the charges were going to be brought against President Clinton in the House of Representatives. It could have been everything, and it was allegations of perjury in connection with the Paula Jones deposition, allegations of perjury in connection with the testimony in front of the grand jury, obstruction of justice, improper claims of executive privilege, things like that. And so what we were arguing primarily we were forced to argue primarily in the House, was not the truth or the failure of any of these things, but that none of these misconduct, even if you conceded them all, and he had engaged in some wrongdoing, but none of this conduct rose to the level of an impeachable offense. It was not an exercise of presidential power in a criminal way or an abusive way that threatened the body politic. And that's why I read that quote from Chuck Ruff. Now, I happen to believe that they picked 2 articles. We might have had trouble with some of the other articles in terms of the proof, particularly his testimony in the Paula Jones deposition, but I think we had no problems defending his conduct on the facts and on the evidence in the 2 articles that the House of Representatives decided to send over to the Senate. One was that he allegedly lied in front of when he testified for 4 hours in front of the grand jury. Fortunately, we had all 4 hours of tape that the people could look at, that the Senate could look at, and it was really quite clear that I thought the House of Representatives got that allegation confused with the Paula Jones testimony, because when he testified in front of the grand jury, he acknowledged an improper and inappropriate relationship with Monica Lewinsky. He wasn't denying it. And I spent 3 hours on the floor of the Senate with clips from his deposition testimony in Paula Jones and with clips of the video of the testimony in the grand jury, showing that what he had done in the grand jury was truth-telling. And people shouldn't make that mistake and mix it up with what happened in the Paula Jones deposition. So I felt very comfortable defending the president on the merits, on the facts, and on the evidence in the Senate trial. I had no problem whatsoever making the argument, and I did to the House Judiciary Committee, that his conduct, in some respects, in his private capacity, was maddening. That was the word I used, maddening, and enraging, and blameworthy. But it did not rise to the level of an impeachable offense where the Congress of the United States should remove him from office, should negate a democratic election, because it was not what the impeachment clause was established to do. And you can cite all the Federalist Papers and Madison and Hamilton, that is to protect the body politic, just as Chuck Ruff said. And there are no, the point I was making was that there are no real standards that get imposed on that political process, but there is a rule of law function that is going on there. There is an understanding that the reason that that impeachment clause is there is to protect the country from dangerous presidents. Yes, sir. But thank you for your question.
So my question is this. In thinking optimistically about the prospects for restoring the rule of law, as you suggested, are you worried at all that the major structural impediment at work here is the staggering inequality, economic inequality that we find around us? And you mentioned the 1950s as a low point in rule of law norms in this country, and there were some problems there, but when I think of the low point in rule of law in American history, at least modern American history, I think not of the 50s, but of the Gilded Age and the Jazz Age, when there were thousands of lynchings and corruption predominated throughout the entire political system in this country, and a set of very wealthy families, all of them corrupt, wielded enormous authority outside of the law. All of that happened. Unionists shot down in the street, the judiciary, a complete mockery. And it's conspicuous to me that the last time we saw in this country the kind of economic inequality that we see today was conspicuously in those periods. Again, the Gilded Age, the Progressive Era, and the Jazz Age, the 1920s, really until the 1930s. So I just throw that out there as someone who, like yourself, has thought and thought seriously and in a worried way about the prospects of rule of law, and I worry now.
Yes. Thank you. And one of the problems, of course, is structurally, you heard me comment how it seemed that vested interests back in the 60s, when there was a war on poverty, and we had a president who was committed to the idea of trying to do something about the inequalities and do something about particularly rural poverty. But the structural situation in the Congress then has gotten worse now, because I think the role of money in politics today is much, much more pervasive, arrogantly pervasive, and visibly affecting the way people conduct themselves in Congress, both in the House and the Senate, than it was in the 60s. Now, how do you solve that problem? It's become structural because the Supreme Court has now said that corporations have a First Amendment right to, to spend their funds on issues that are related to candidates running for election. And so suddenly there is this enormous amount of money that's flooded into every election that they care about. I don't know if you've read Dark Money by Jane Mayer, but there's chapter and verse about the way in which not only just elections and the rule of law, and then systematically the courts get changed over time. And I just cite one example in my speech, but also universities, think tanks, sort of the space where people are freer to be dissenters is closing because of the power and influence of money on those institutions. So the answer is I share your concern.
So regarding your comment about the judiciary being a mockery, I think it was, We have
I didn't say it was a mockery.
this gentleman referenced it in his comment, not you. We have serious problems with the judiciary locally. I mean, really serious problems. And so my
Talking about
question,
Boulder.
I'm talking about Denver Metro from north to south. And I'm not speaking about Boulder directly in any specific way, generally regarding like disorderly conduct, laws, trespassing, obstruction of a police officer. So I have this article, Help Make Judicial Complaints Matter. It starts off 97%. That's the dismissal rate of complaints against judges in Colorado. And keep in mind, all judges are attorneys, right? So this speaks to what can the young attorneys up and coming do to change, to turn this around. The rate hit 97% in 1993 and has averaged that ever since. What is being alleged in all those dismissed complaints? We can't find out because the language in the Colorado Constitution requires their content to be kept confidential. And the language in the state constitution is also why the dismissal rate of complaints against judges is so high. So there's serious abusive law going on by judges that I can document and their staff, court staff. And when you follow rule of law to address that, they just ignore it. And they claim that it's not this agency that has jurisdiction and push you on to another agency. So what is an attorney, knowing that all attorneys become judges, right? That's what a judge is an attorney. What responsibility to those of you with gray hair, as I have, take for getting us to this point, and to the young judges who are up and coming? You need to hold yourself to a higher ethical and moral standard in your practice of law, because what's happened is the gray-haired judges have practiced our rule of law into the ground. And to turn it around, it's going to be up to you young folks without the gray hair. And it's a huge, huge challenge. And I would also challenge the dean of the law school to ensure that the culture of the law school is not, which it is, similar to the culture of the business school, right? You need to downsize your egos and realize that you are public servants and that you've practiced our law into the ground.
Let me just comment briefly on something, because I really can't speak with any understanding or authority or insight into the situation of your judiciary here. I can say with some experience myself about the federal courts that one of the reasons that we have problems attracting the highest quality public spirited lawyers to the federal courts is that we don't pay our judges enough in the federal system. This is something, by the way, that Republicans and Democrats agree on. The Chief Justice every year comes and delivers a message on the state of the judiciary to the Congress. And the Republican president that preceded President Obama supported increases for the federal judiciary, and certainly President Obama did as well. And it still hasn't happened. And so what has happened now is we rely on people who are already successful materially in life to go into the federal courts, or people who are using the federal courts as a springboard to greater income. I'll go in and be a federal judge for 5 years, and then I'll come out and go work in a high quality, blue chip law firm and make money. So I think the federal system can only survive that kind of wearing away and erosion for a small period of time before it's going to have a real impact on the quality of the justice that we give out in the federal courts. Yes, sir. Down here, would you like to say something? Right here. A microphone is on the way.
Asking as a non-lawyer, I keep hearing commentary on the media that if this or that egregious behavior happens, we're going to have a constitutional crisis. And then these behaviors happen and we don't seem to. So my question is, what is a constitutional crisis and how would we know if we're having one?
You have just replicated 17 different conversations that take place in front of the talk shows in green rooms among people that are going on television every Sunday morning about what a constitutional crisis is. I don't think, as I said, I tried to say, I don't think we are in the kind of constitutional crisis that we have experienced in the past and survived, but we're close to it. And a constitutional crisis would be where, for one reason or another, one of the branches of government is unable to perform and the country comes to a halt. That's one definition of a constitutional crisis. Or one branch is trying to get rid of the leadership of the other branch. The branches are so pitted against each other that the country is not able to govern itself. There could be other kinds of constitutional crises involving the military exercising its authority and taking it away from the civilians. So constitutional crisis is a broad term that is overused and I think not used accurately. We've got real problems. I think we've never had a president quite like this president, and so we're trying to decide, is this a crisis or is it not a crisis? Are we going to manage it? Are we going to survive it? And I will tell you that I've listed a number of things that I thought were unusual in terms of the attack on the norms and the culture and the conduct of government activities that are inconsistent with the rule of law. And I'm not sure that can go on forever. But I will say one thing. There will be no impeachment of President Trump unless and until the leadership of his party want that to happen or are part of the effort to make it happen. We learned in the President Clinton experience, this is not a comment that I'm making anything other than a historical observation. We learned in President Clinton's impeachment that whatever the merit of the allegations might be, you can have a partisan impeachment, and that was what that was. All the Republicans voted to impeach President Clinton, but you cannot remove a president of the United States unless it's a bipartisan effort. And that's why Clinton was not removed. It was so partisan coming in. There was such disagreement and polarization about the propriety of removing the president for the activities he engaged in with Monica Lewinsky, that it never was going to happen without a bipartisan support. I think that's true for Trump as well. One last question, and then we'll call it quits. How are you?
Thank you. Thank you for your talk. Enjoyed it
Not
very
at all.
much. So my question really, I think one of the strange things about these times more than ever is that, you know, liberals and the far left and criminal justice advocates have more in common with civil libertarians and libertarians than ever before. But with regards to the rule of law, what I'm really interested in your perspective on, and I don't know the answer really, is, you know, as lawyers eventually, you know, we all take an oath to uphold the law, and it's the same, you know, in the military. And yet, even though, you know, our culture and our oath has to do with respecting the rule of law and respecting the ruling of judges, I think that most of us would agree, if we look back on history, you know, whether it's Dred Scott or Korematsu, and you said, well, you know, if you were there knowing what you know now, would you abide by that decision? Would you fight it? Would you technically violate the law? And, you know, you were in the 60s, I think, you know, we did. And, you know, I'm just interested in, you know, just to cite two examples, you know, as the DACA issue and as the travel ban issue, which circuits coast to coast, liberal circuit, conservative circuit, have both been one way on. You know, as these go up to the Supreme Court, and there certainly could be other issues, if the Supreme Court, you know, finds the other way, you know, even though that is a legal decision, where is that flex point between, okay, the Supreme Court has spoken, but 50 years, you know, from a historical perspective, folks are going to look back and say, you know, I wish we hadn't followed that, with regards to just those two issues or other issues as well. Thank you.
Well, I said that the American electorate doesn't always get it right. It's fair to say the Supreme Court does not always get it right, but it takes history to be able to pass that judgment ultimately. I mean, if the Supreme Court says this is the law and the lower courts should apply it, lawyers who are raised in our system can argue against it and can litigate against it, but if you're a judge, that's the law that you apply because that's the law of the land. I will tell you an interesting experience I had on the issue of Donald Trump's criticism of judges. which has gotten a lot of my friends very angry. When President Obama was president, we had a nominee for a federal district court judgeship in Rhode Island. He was a very active trial lawyer, and we were very eager to have a trial lawyer on the federal bench. It's very hard to get either from the defense bar or the plaintiff's bar people to go on the bench. You get prosecutors, you get academics, but you don't get real trial lawyers who are engaged every day in representing either federal defenders, public defenders, or mass tort plaintiffs' lawyers. So we got this fellow, and the ABA committee held him to be unqualified because he didn't have the appropriate demeanor. And he had written an op-ed in the local newspaper in Rhode Island criticizing an opinion that the Supreme Court had issued on his case. He'd won a case against companies that were selling lead paint to families and children, and he believed that he had established a causation nexus between the sale of the paint and the children's maladies. And he won a big case below, and the Supreme Court of Rhode Island reversed the case, and he wrote an op-ed saying that it was wrong. And the ABA said he cannot be in the federal courts if he did that. And I said, that's nuts. Look, everybody should have a right in an appropriate way, in a professional way, to complain about what a court does. Courts are not above debate or criticism. You don't just salute and march off and do what the court says. You have the freedom to say, I don't agree with it. Then you have the obligation, if you're a judge, to carry it, if it's the Supreme Court, to follow through. And we talked the ABA out of it. He was confirmed. He's a great judge. He's a very popular judge in Rhode Island, I think among some people, not so much among others. But I am slow to criticize Trump for criticizing judges that he disagrees with. I'm not slow if he criticizes a judge because he's a Mexican, or if he says something that's inappropriate that makes it appear as though he's motivated by corrupt or political or personal. There are ways of criticizing an opinion that are appropriate and consistent with the rule of law, and there are ways of criticizing judges that are inappropriate and inconsistent with the rule of law. And I think we're smart enough to know that difference. Thank you very much for being here. You're a great audience.